Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Today we are going to discuss a case law on section 12, subclass 2 of the Limitation Act. You may be knowing the contents of section 12. So it gives an exclusion for the time taken to obtain the judgment copy. No doubt the judgment may be delivered on some date. You have to go in appeal within 30 days or 45 days as for the time frame. And if you are not able to get the certified copy within 10 days or 15 days, that time also will be excluded. Here there is an explanation also. The time taken by the court to prepare the so-called decree is not at all computed, and the first day will be excluded. Suppose the judgment is given on 30/12/2019, so the limitation starts from 31/12/2019. This is all general knowledge, but still people take advantage, and now they have failed in this particular case. You can see this case as V. Nagarajan versus SKS Ispat&Power Ltd. 2021. Ispat means steel, right? So this case was decided on 22nd October 2021. That means just before, 2 days before only. While disposing this case, you can see the citation in Live Law 2021, page number 581. 3 judges bench of Honorable Supreme Court India, consisting of Justice D.Y. Chandrachud, Justice B.V. Nagaratna and Vikram Nag. They clearly held that the application for certified copy should be filed before the limitation period. Please remember, application for certified copy should be filed before the limitation to get the so-called exemption under section 12 of the Limitation Act. Right? Actually, this Nagarajan, V. Nagarajan, he is an official liquidator for certain company, Sethar Limited. Right? So, actually it is under the process of dissolution. So at the time he was appointed as an official receiver, and while going through the documents he came to know that this Sethar Limited in collusion with SKS Power and Ispat Ltd. Yes, they have manipulated or they have waved away about 400 crores of rupees, and they wanted to go for bankruptcy under the Insolvency and Bankruptcy Code 2016, which is not correct. So therefore he wanted to file an application against these people. Of course, when he filed the same before the NCLT branch Chennai, it was dismissed because of the so-called limitation period is over. So here what happened is the tribunal gave the order on 30th of December 2019. Please remember carefully. 2019 the judgment was pronounced. So the appeal has to be filed within 30 days. For example, 15 days period, 45 grace period will also be given, 45 days. When will that end? That will end by 14th February 2020. Right? But here, please remember, the order dismissing the petition of Nagarajan was not uploaded. It was uploaded only on 12th March 2020. That too, in an irregular order with so many mistakes. The correct order was uploaded on some other day, that is 20th March. Yes, 20th March 2020. But remember, from 22nd onwards, the corona pandemic and the Janata curfew, all these things here, and the court's NCLT has been closed. And after the virtual proceedings, that is standard operating procedure for virtual proceedings have come, it was reopened on, I think, 24/3/2020. Right? Later on 8/6/2020. So this man has filed the appeal with a freely downloaded copy of the judgment. Please remember, Rule 22 says that whenever an appeal is filed against an order, the certified copy has to be enclosed. Here they have not enclosed any certified copy. only downloaded copy has been enclosed. That too. So here it is very clear that the appellant Nagarajan has not taken any efforts to obtain the certified copy. What he has done after he was present in the court, in the tribunal on 30th December when the order was dismissed. So it is his duty to file it within 45 days. Of course, if he has filed for a copy of the certified copy, the time taken by the court, maybe 1 month, maybe 15 days, it would have been excluded. But it was not done. Ultimately, he filed only the downloaded copy. Of course, Rule 14 allows the downloaded copy also. Now, Supreme Court has clearly stated that it is the duty of the so-called appellant to obtain a certified copy. If there is a delay by the court in giving the certified copy, yes, it will be allowed. But the time taken by the court to upload the same into the so-called public website, it will not be computed as per the explanation in section 12. Therefore, the appellant has merely failed to apply or to apply for the certified copy, due to which he cannot claim any limitation. Petition dismissed. So please remember. So as an example, I told Mr. Singh also. I told you, suppose if you file application for the certified copy, you don't take the copy. The copy is ready, but you don't take the copy within 30 days. So having taken the copy, and from the date, the computation, the limitation will not be excluded. Please remember. That's why whenever you get a message that your certified copy is ready, you have to take it within 1 or 2 days. So you cannot simply apply for a copy and sleep on the issue. That's why vigilantibus stantibus, you all know, the law comes to the rescue of a person who is vigilant but not the sleepy or slumber persons. So to sum up, I want to tell you that please remember, it is your duty to obtain a certified copy of the judgment. Right? If there is any time taken by the court to supply you the certified copy, that period will be excluded under section 12. But please remember, the time taken by the court to upload the same into the public domain will not be taken into consideration. There the case has failed. Right? Thank you very much.